this year about disgruntled buyers in the MGM signature residences. Our executive producer Dana Gentry is here right now with an update. Dana.
Jeff, you'll remember some of those buyers claim they were misled by sales agents who told them they could pay for their investment by renting out their units for rates comparable to luxury hotels. Well, that hasn't happened. Instead, the buyers say they've come out of pocket to pay their mortgages. They claim the sales should have been registered as securities. Back in December, a judge ruled the buyers were bound by an arbitration clause in the contract, but the state Supreme Court says it may examine that clause and ultimately send the dispute to a jury trial. The attorney for the buyers says the Supreme Court's decision to review enforcement of the arbitration clause contained in the purchase agreement is a significant development to the unit owners, who contend that the arbitration clause is void and unenforceable under state securities law, as well as procedurally and substantively unconscionable in that it does not provide a knowing waiver of important consumer legal rights. The unit owners have requested that the matter remain in state court and be tried before a jury. The MGM's response: the plaintiffs and their several lawyers object to honoring their contract with Turnberry MGM and to disposition of their complaints by arbitration. They have petitioned the Nevada Supreme Court with, in our opinion, false and inflammatory arguments and overblown rhetoric to ask the court to overthrow the signature contract and countermand Judge Denson's arbitration order. Jeff will keep you updated on this case. We understand buyers of condo hotel units and some other developments may soon be making some similar claims.
All right, Dana, thank you very much. Officials broke ground this week on Union Park, the development that they hope jumpstarts the redevelopment of downtown Las Vegas. Union Park will go on the 61 acres of vacant land west of downtown and bordered by the railroad tracks. Once completed, it will include a 2,000-seat performing arts center, the World Jewelry Center, and the Lou Ruvo Brain Institute, which is set to open first, actually. Las Vegas Mayor Oscar Goodman says the development is a sign that Las Vegas is becoming more than a tourist destination.
You know, we're the entertainment capital of the world, the tourist destination, the best of everything, but to become a community that celebrates great medicine and great art is something that one would have bet against a little while ago.
Union Park is scheduled to be finished by 2012. The Las Vegas Planning Commission has given the go-ahead to a hotel that would be as big as anything on the Strip. The Grand is slated for the northeast corner of Charleston Boulevard and Grand Central Parkway. At 61 stories, it would tower over anything downtown. The Grand would have 2,500 hotel rooms and would draw customers from the World Market Center and Union Park, just to the north. Dozens of downtown property owners who signed deals to sell to a would-be arena developer are still waiting. The city council has granted numerous extensions to REI Neon, but to no avail. And now the Las Vegas Sun reports the arena may move actually closer to the stratosphere, leaving the downtown property owners out of luck. Officials close to the deal say the property owners were asking 2 to 3 times their land's value, which may have put the project out of reach. A state Supreme Court ruling gives landowners some protection from drawn-out government land grabs. The court ruled property owners may sue for pre-condemnation damages when a government announces its intent to seize property and then unreasonably delays filing the action. Joining me to talk about all of this is Eminent Domain attorney Autumn Waters. Great to have you on the program, Ms. Waters. So, I mean, when you read this decision, what does the court mean by unreasonable delay?
And they left that up to the jury, the fact finder, but they made point to mention that in California, unreasonable delay is anything over 6 months. So it could be anything, and it's up to the jury to decide. Could it be 3 months? Possibly, depending upon the fact scenario. Could it be a year? Possibly, but they gave a guidance as 6 months.
But the final decisions of the jury on this one.
Yeah.
How does this opinion strengthen a property owner's hand, really, regarding eminent domain?
Well, it's a wonderful decision for landowners in Nevada, because what has happened in the past, and in other states also, is that the government will approach the landowner and say, we want your property. And then they'll go get a resolution need necessity. And what that does is that puts the whole world on notice that that piece of property is going to be taken by eminent domain. And then they can just sit and wait and wait and wait and wait. And the problem with the waiting is that it's economically crushing to the landowner, because they can't sell the property unless it's substantially reduced value. They can't get a loan on it. They just have to wait. And in one case in California, the landowner actually had to file bankruptcy because of the delay. And so this means the landowner doesn't have to wait. They can go ahead and file and try to recover some of the damages that they're seeing.
You mentioned this need and necessity resolution, which is what actually happened in this case. So is the court saying in this case that, okay, city, once you give a need and necessity resolution, you're kind of on notice here that you really have to follow through with this?
Yes.
Yeah.
Yes, that's what they're saying. Get on with it.
Yeah.
Don't let the landowner just stay out there and suffer. And that's what has happened in the past.
Right. So the bottom line then is that the government here is liable for damages if it frankly drags its feet.
Yeah, if the landowner has suffered damages, absolutely.
Yeah. Why was this needed after the Pistol Compromise, do you think?
A little different situation. And this actually, the facts that came about from this are different and were before Pistol. Pistol was in 2005, if I recall correctly. The resolution need necessity, and this was in 2003.
So Pistol isn't a cure-all, really, essentially.
You can't cover everything.
Yeah.
It covers a lot of stuff, and it helps landowners, but you can't cover everything.
What kind of impact do you think that this is going to have on municipalities?
I think a big one, because they are going to now have to move forward. If they tell the landowner this is happening, they're going to have to move forward. In addition to that, sometimes the municipalities were using this as a tool. The longer the resolution need necessity sat on the property, the lower the value of the property was. Right. And the lower the value of the property was, by the time they got around to condemning it, they're getting a discount, a significant discount in many cases.
Essentially getting a break on the price. Big break. Ms. Waters, we're out of time. Thank you for joining us. Appreciate it very much.
Thank you.
When in Business comes back today, a new school offers Las Vegans the chance to learn the ropes behind some of the Strip's biggest productions. Plus, John Ralston tells us why the backers of those initiatives are taking their time revealing who's behind the bankroll.